The Supreme Court has just heard oral arguments in a case that will literally shape the future of the internet as we know it. That case is Gonzalez versus Google, and it asks the Supreme Court to decide a rule that will determine how websites like YouTube, Twitter, Yelp, and other social media companies can rank, display, and suggest content to its users without having to fear lawsuits for harmful content uploaded to the platforms by other people. The Gonzalez case stems from a tragedy that occurred in 2015. Naomi Gonzalez was a U.S. citizen who was studying abroad in Paris at the time. One day, while she was dining in a bistro in Paris, a gunman opened fire on the crowd. Sadly, she was among one of the 129 people who were killed in that attack. ISIS claimed responsibility for the attack. Now, Naomi's grieving family filed a lawsuit against Google, which owns and operates YouTube. They claim that YouTube should be responsible for their daughter's death because the video recommendation algorithm that YouTube was using recommended ISIS videos to users who the algorithm identified as someone who would be interested in such videos, thereby promoting the spread of that extreme ideology among YouTube users. The family's complaint alleged that YouTube's recommendation of these videos was a contributing cause of the 2015 attack that killed Ms. Gonzalez. The lower courts dismissed the lawsuit, however, and ruled that a law that Congress had passed at the dawn of the internet back in 1996, known as Section 230, shielded YouTube from liability for user-created content on YouTube. The court held that Section 230 protected Google from liability because the recommended videos were produced by ISIS, not YouTube itself. The family then appealed that decision to the United States Supreme Court, and the court agreed to hear the case. On February 21st, the Supreme Court held oral arguments in that case for almost 3 hours. Google's lawyer summarized the other side's argument before totally dismantling it.
Mr. Chief Justice, and may it please the court. Section 230 C1's 26 words created today's internet. C1 forbids treating websites as, quote, the publisher or speaker of any information provided by another. The other side agrees Section 230 bars any claim that YouTube aided and abetted ISIS by broadcasting ISIS videos. So they instead focus on YouTube's organization of videos based on what's known about viewers, what they call targeted recommendations. They say that feature can be separated out because it implicitly conveys what viewers should watch or that they might like the content. But accepting that theory would let plaintiffs always plead around C1. Search engines thus tailor what users see based on what's known about users. So does Amazon, TripAdvisor, Wikipedia, Yelp, Zillow, and countless video, music, news, job finding, social media, and dating websites. Exposing websites to liability for implicitly recommending third-party content defies the text and threatens today's internet.
Blatt warned that ruling against Google in this case would result in YouTube becoming either FilthTube, where YouTube turns into an unmoderated horror show, or the other extreme, a dystopian FluffTube, where YouTube removes everything except the most G-rated happy talk content.
And so you have one of two things happen that would happen and would have happened then and would happen now. The first is websites just won't take down content, and that just defeats it the whole point. And you basically have the internet of filth, violence, hate speech, and everything else that's not attractive. And the second thing, which I think a lot of the briefs are worried about in terms of free speech, is you have websites taking everything down and leaving up basically you take down anything that anyone might object to, and then you basically have, and I'm speaking figuratively and not literally, but you have the Truman Show versus a horror show. You have only anodyne, cartoon-like stuff that's very happy talk, and otherwise you just have garbage on the internet.
Both the liberal and the conservative justices expressed a lot of concern that a narrow interpretation like that would lead to an avalanche of lawsuits that would disrupt the internet and basically ruin the internet, as some media outlets have said. Justice Kavanaugh expressed concern about the rise of lawsuits that would result if the U.S. position was adopted by the court.
If we go down this road, I'm not sure that's going to really pan out. Certainly, as Justice Kagan says, lawsuits will be nonstop on defamatory material which there's a lot of, that is out there and finds its way onto the websites that host third-party conduct.
And
There'll be lots of lawsuits. You agree with that?
I wouldn't necessarily agree with there would be lots of lawsuits.
Bigger picture then to the Chief's question, isn't it better to keep it the way it is for us and Congress, to put the burden on Congress to change that, and they can consider the implications and make these predictive judgments? You're asking us right now to make a very precise predictive judgment that, don't worry about, it's really not going to be that bad. I don't know that that's at all the case. And I don't know how we can assess that in any meaningful way.
Justice Kagan suggested that Google could be immune when its algorithm recommends content as a practical necessity of organizing and presenting content to users.
You can't present this content without making choices. So in every case in which there is content, there's also a choice about presentation and prioritization. I mean, you are creating a world of lawsuits. Really, anytime you have content, you also have these presentational and prioritization choices that can be subject to suit.
Justice Alito then threw a series of softball questions to the Google lawyer, Ms. Blatt, prompting her to explain how ruling against Google would effectively lead to the collapse of the internet as we know it.
Would Google collapse and the internet be destroyed if YouTube and therefore Google were potentially liable for posting and refusing to take down videos that it knows are defamatory and false?
Well, I don't think Google would. I think probably every other website might be, because they're not as big as Google. So what you would have is a deluge of people saying, you know, that restaurant review was, you know, you said my restaurant review, I didn't like it. I think Yelp does an amazing job on this, about how much they got hit and had to spend, you know, almost crushing litigation because they were being accused of being, you know, biased on reviewers, and everyone, no matter what, they couldn't win for losing or lose for winning, whatever the phrase is, because whoever got reviewed, somebody was upset. And so I think those websites, they never would have happened, and they probably would collapse.
Other justices just simply expressed confusion over the Gonzalez family's argument. They just didn't understand what exactly the Gonzalez family lawyer was arguing. For example, here is a clip of Justice Thomas.
Which is hard. It's hard for me because I don't see this. I see these as suggestions and not really recommendations.
Whether we label it a recommendation or not, on our view, is not the issue here. We tried to say that in our brief. Was that responsive? I'm not.
Well, it's responsive, but I don't understand it. You called.
Justice Alito expressed similar confusion about the Gonzalez family's position.
I'm afraid I'm completely confused by whatever argument you're making at the present time.
Justice Kagan even acknowledged in a more humorous moment that the 9 justices are not exactly experts on the internet.
I mean, we're a court. We really don't know about these things. You know, these are not like the 9 greatest experts on the internet. And I don't have to accept all Ms. Blatt's "the sky is falling" stuff to accept something about, boy, there is a lot of uncertainty about going the way you would have us go, in part just because of the difficulty of drawing lines in this area, and just because of the fact that once we go with you, all of a sudden we're finding that Google isn't protected. And maybe Congress should want that system. But isn't that something for Congress to do, not the court?
Well, I think the line drawing problems are real. No one minimizes that. I think that the task for this court is to apply the statute the way it was written.
Justice Jackson appears to believe that Section 230 does not protect Google from YouTube's recommendations of harmful content to viewers because it amplifies the content to millions of viewers who would not have otherwise seen it.
Ms. Blatt, I guess my concern is that your theory seems to bear no relationship, in my view, to the text of the actual statute.
Sure.
I mean, when we look at 230C, it says protection for Good Samaritan blocking and screening of offensive material. You're saying the protection extends to internet platforms that are promoting offensive material. So it suggests to me that it is exactly the opposite of what Congress was trying to do in the statute.
Well, I think a lot of things are offensive that other people might think are entertaining.
Now, before predicting the outcome of this case for you, I'm going to share several thoughts and observations that I had in listening through the oral arguments. First, the issue in this case does not appear to be a partisan one. This is not going to be a case where you have all of the liberal justices voting one way and all of the conservative justices voting another way. It seems like both liberal and conservative justices were resistant and reluctant to embrace the position that was advocated by Gonzalez's attorney. Second, the fact that so many tech companies filed amicus briefs in this case helped the justices understand the gravity of their decision in this case and the far-reaching implications that it will have on the digital economy and access to information on the internet. The justices referenced the amicus briefs multiple times and asked questions using hypotheticals taken directly from amicus briefs, including Microsoft's excellent amicus brief. The third thought that I had in listening to these oral arguments is that the Gonzalez family's position in this case is simply too confusing to be persuasive. Several justices told the Gonzalez lawyer that they were confused during the oral arguments. This is not a good sign. A Supreme Court decision is supposed to bring clarity and uniformity to the law, not create a tedious and confusing legal test that is impossible for lower courts to follow. So don't be surprised when the Supreme Court rules in favor of Google, which I think it will. If you like this video and you want to see more on this topic, let me know by leaving a comment below, and make sure to hit that subscribe button below and turn the bell notification icon on. And of course, as always, thank you for watching.